Welcome back to the morning show here on Arise News. On Friday, July the 5th, the Supreme Court of Nigeria, in a majority decision, ruled against Senator Ademola Adeleke of the People's Democratic Party in a suit brought by him seeking to be declared winner of the governorship election in Osun State, Nigeria. In their ruling, the justices upheld an earlier judgment of the Court of Appeal, which held that Gboyega Oyetola of the All Progressives Congress had won the election, which took place in November 2018. That judgment of, is it November or September? September 27, yeah. September 22, September
28.
27.
Now I'm 20.
22,
now I'm getting
27.
confused.
The judgment of the Supreme Court has been the subject of several interpretations and analysis. And joining us now for more analysis is Evans Ufeli, a constitutional lawyer and human rights activist. He's here to talk about whether the cause of justice has been served or not by the majority decision which settled the case on the basis of a technicality. Evans Ufeli, good to have you on the morning show.
Good morning.
Thank you. Good morning.
Yeah, well, I've just tried to introduce the subject. But what we hope that you will help us do is a review of that Supreme Court judgment, which has generated a lot of concern. Whether, technicality is more important than substance, and whether procedure should be more important than the real rest of the matter, which, their lordships seem to have ignored. What's your take?
Yeah, my take on it is that if you look at the matter deeply, you will find out that the merits of the matter was grossly ignored. And then we have a voyage of technical display and issues that ought not to have been placed too much premium on. You see, from the tribunal, the tribunal had declared Adeleke the winner of that election, given the quantum of evidence that was adduced, the question of substantial non-compliance with the Electoral Act, and how the substantial non-compliance affected the result, the question of the 17 polling units, that they had a rerun.
Seven? Was it 17 or 7?
17 polling units.
Okay.
17 polling units, yeah. Where they had a rerun, which was set aside by the tribunal and all that. Now the Court of Appeal, while the case was before it, decided to go the other way around, to say that one of the justices, Justice Peter Obiora, was not in one of the sittings where evidence was adduced and all that. And as a result of that, he couldn't have understood what transpired, and whatever judgment he gave that day was procured from hearsay, which is not admissible, and then he has no jurisdiction to do such. And on the basis of that, the court now went in favor of Oyetola, who is the APC gubernatorial candidate in the election. Now, the question now is this. When you say that he was absent, you ought to depose an affidavit to that effect with the records of court. At the Court of Appeal, we had no such thing. There was no records of court exhibiting that he was not present. They only say he did not sign the register. Even at the Supreme Court, sometimes the justices don't sign the register. The only way you can come to proper evidential and probate value of an assertion is to adduce evidence through the records of proceedings of the court. And that was not done at the Court of Appeal, And the case went to the Supreme Court. And then the Supreme Court now looked at it again and then faulted Justice Peter Obiora's absence again, which is as the basis for their judgment. Now, what I see in all this is that we have left the substance of the suit, forgotten the substance of the suit. The question of the Electoral Act, which is the substantive and extant legislation on electoral matter. The Electoral Act, the substantial non-compliance, and how the substantial non-compliance affected the result. Those two issues, the issues of vote buying, the issues of thuggery, brigandage, and all that characterized that election were all kept aside. And then we focus on technicality. Why I'm saying this and why I'm so passionate about this is because the sins of the court should not be visited on the litigants. Litigants come to court. The reason they come to court is to seek remedy. It's because they would not take the laws into their hands. It's because they will not want to create a situation that will lead to a breakdown of law and order. Now, when they are in court, if the court had made any mistake in the process of adjudication, such mistake and such errors should not become the burden of the litigant. It is not equity. It is not justice.
Quite correct. But will it have made a difference if, Justice Peter Obiora had been placed on oath because he had denied that, it's not that he was absent on February 6, 2019 at the tribunal. He said indeed he was there, but that he forgot to sign the register. And Justice Ntambaba, who offered the dissenting judgment at the appellate court, the Court of Appeal, had made it clear that that was not strong enough a reason, because in fact the error could even have been that of the registrar. Will it have made a difference if he was just asked to take an oath and affirm that indeed he was there, and then the Supreme Court could have, on the basis of that, taken a look at the real substance of the matter? Well,
it would have made a difference, but that opportunity was not given. Because at the level of the appeal, at the governorship election, the Supreme Court only have appellate jurisdiction, don't have original jurisdiction. So what they would do usually is not to call witness or call anyone to come and testify,
so
whatever.
They
will review, yes, what is before it, what has been decided by the lower court, and look for issues that are not well placed, and because the Court of Appeal have said that setting aside the rerun was a patent error of the tribunal, okay? But that is not sufficient. Okay, what about the substance of the matter? What about the allegations? What about the evidence? What about the proof from polling unit to polling unit as prescribed by the Electoral Act that you have in that election? So I think that we must go back to the principles of justice and look at what justice really is. Because justice is supposed to take into consideration, okay, the fact of the case, okay, the component of the litigants, the evidence of the litigants, and then the court will hinge its decision on substantial justice and not technical justice. Because what we have here is technical justice. And then it is saying a lot about the judiciary. Because if the judiciary is the last hope of the common man, then I think that it is his duty to make sure that justice is seen.
That's where,
and seen as manifestly done.
That's why I'd like to jump in, because in layman terms, right, we're speaking about a lack of records, we're speaking about a lack of opportunities, we're speaking about so many lacks in such a big case, right? So let's speak about judicial reform for a second, because clearly there is a serious lack of structure within Nigeria's judiciary, and it's leading to issues such as this. What sorts of judicial reform do we need to be looking at? Because we cannot go on running a justice system like this.
Well, the kind of judicial reform we should be looking at is one that is watertight in its approach to issues, one that gives human face to litigation, not the one that ties strings to technicalities and procedures. You see, you cannot, you see, the reason the principles of equity, the Judicial Act, came to supplement the common law is just what we have. The common law was the first form of law in ancient England, where they stick to the strict rules of law. If you have a mortgage system, for example, once it is a due date and you are still in default, the company takes over the property. Now, you could be in default for several reasons. Maybe due to ill health, maybe due to an act of God, maybe due to sudden death and all that. So those factors were not considered. So the Lord Chancery then, the people were coming to him to ask, to complain that this system cannot be the system that will give us justice. What happened? The Lord Chancery started looking at the merit, looking at why did you default, why and all that, and why they incorporate all that. The principles and the doctrine of equity was enacted. Equity now came to supplement the law. And then equity now have a lot of remedies in it to supplement the law. So in this case, where you're talking about judicial reform, our judicial reform should tend towards equity and its principles so that litigants, okay, will not come to court and then have issues of this nature. Because if you throw away any part or any fact of a case and then look at just one side of it, which is not even the fault of the litigant, which is the fault of the court of first instance, and then all judgments from that point to the Supreme Court is hinged on just that, then there's a lot of questions to answer.
Well, I mean, you used the word earlier on, about, you said this says a lot about the judiciary, and I wrote it down. This says a lot about the judiciary. Is it really about the judiciary as an institution or about the present Supreme Court as constituted? Cast your mind back. If this were the court of the Oputas, the Irikefes, that generation, the Namanes, their own court, their own Supreme Court at that time went beyond legal positivism. They ran a court that was based on the concept of judicial activism. Okay, do you think, this is not, will you revise your earlier statement and say, this may not be necessarily about the judiciary as an institution, but about the present Supreme Court?
Well, why
and if you swing one way or the other, what would be the explanation?
Yeah, why I say it's about the judiciary is because the Supreme Court is an offshoot of the judiciary. So if we're going to talk about the problems at the Supreme Court, we will not...
It's a court of last resort.
Yeah,
even when there are errors at the lower court.
Yes.
You expect a robust Supreme Court.
Yes.
To deliver the law.
Yes.
And ensure justice.
Yes.
Be more justice-oriented.
Yes, that is what it is. So the kind of thing we're seeing now at the Supreme Court is what should have occurred in the court of first instance for the Supreme Court to correct. That's what I'm saying. What we're seeing there is what should have happened in lower courts for the higher court to correct. But I still think is the judiciary, because you cannot separate the Supreme Court from the judiciary. In fact, the Supreme Court is the head of the judiciary. Because that is where the CJ sits. That's the office of the CJ.
They are playing safe. You don't want to criticize their lordships.
Well,
I'm giving you an opportunity to do an assessment.
No, exactly. What is your assessment of the Supreme Court?
Well, over the years, the Supreme Court have been a very fantastic one over the years. If you look at the judgment from the Supreme Court, he just stated a particular generation. Even the current generation of the Supreme Court, okay, they've had robust issues. I mean, from the Supreme Court of Nigeria, we have been able to export judges to many African countries, over 15 African countries, okay? And then even in to the International Court and all that. We have the capacity. But in this particular case, where there's a technical and judicial clinch of this matter, okay, we cannot fold our hands and not review the process. It is not a question of criticism. It's a question of lending your voice to what ought to have been, which never became the issue. Because, like I said, the sins, okay, of the courts, of the system should not be visited on the litigants. Litigants are seeking remedy. And then if the court, that is the last hope of the common man, cannot absolutely give that remedy in the way it ought to have done it. I'm not saying that the PDP ought to have been declared the winner and all that. I'm saying that even if you have to, okay, fault them, even if you have to give judgment against the PDP, you need to have considered all the evidence that adduced and not just the absence of a judge.
Evans Ufeli, we'll take a short break and then we'll come back to you and we'll continue with this conversation, which I'm sure is of great interest to a lot of our viewers out there.
Welcome back to the morning show here on Arise News. Evans Ufeli, a constitutional lawyer and human rights activist, is still here with us on the program, and we're discussing the recent outcome by the Supreme Court with regards to the Osun State's elections and your views on that. Before we went on a break, you were making a point, sir. You can continue.
Yes, I was making the point that the substance of the case, every case, okay, you see, because before you arrive at judgment, you must be able to ask all issues properly. Issues that constitute facts, material facts, and evidence adduced. they must be asked on. And it is the deliberate scrutinization of these facts, material facts and evidence, that will inform the court decision. Okay? And not the procedural defect of a court of first instance or any other appellate court. You understand? So if we have to look at this deeply, we will make assertion and call for several kinds of reform in our adjudication, okay, particularly in this case. Because as I speak to you now, this is a judgment that is going into the books. It's going to become precedent, okay? Other cases with similar facts, lawyers are going to argue on the basis of this judgment, okay? I know that the Supreme Court has a power to reverse itself, which it has done that over the years. You understand? But have justice been served in the case that has become a precedent? Or will this precedent now be used to further decline, okay, of our system? These are issues.
Our jurisprudence.
Of our jurisprudence, because because the court is a court of records, okay? Whatever the court have acted on is on record. It becomes precedent, okay? And now lawyers will come in future to use those same precedents to confront the court and say in so year, and in so time, in so law report, in so page, so number, so this same court made this decision. And then there will be pressure, okay, judicial and legalistic pressure on the court to act the same way. Now, lower courts the decisions of the higher courts are binding on the lower court. It's a matter of you can't even move that. So all lower courts now must be bounded by that decision, from the Court of Appeal down to the magistrate courts. Okay? That is why we're saying that the Supreme Court is a court that must put in everything it can in its judgment. Because the implication is that its judgment will become the force of law. So every other court and every other tribunal would derive its inspiration from the decision or authority from that court. And that is why we're saying that it must be a court that will live above board like Caesar's wife. It must be a court that will give sound and robust decision that will correct and strengthen the law. That is exactly my position in this matter.
Well, I mean, Leila asked you a question earlier on about judicial reform. Your position on the outcome of the Osun case is quite clear.
Yes.
And, that position is a view that is shared by many Nigerians, whether they are PDP or they are lawyers or non-lawyers or they are APC or whatever, shorn of emotions or sentiments. But the point she raised about reforming the judiciary, and the point you made about the judiciary. Now, do you think that in terms of recruitment to the apex bench, that, we should open it up a little bit and, allow persons who are not necessarily, part of the judicial system, as is done, say, in Canada, allow maybe university professors to go straight to the Supreme Court, or allow lawyers, in line with the constitutional provision, that for you to go to the bench, you must have spent 15 years, so that we can have a more robust Supreme Court. What do you think of that suggestion, which is one of the things?
Well, I think that it should be opened up, okay? But while opening the space up as a matter of remedy, we should not also compromise the rules or bend the rules, okay? People, lawyers, professors, research fellows who are vast in the issues of law, it should be opened up to them. It should not become a quota system or a tribal arrangement or some kind of nepotic arrangement, because sometimes you find elements of this in our selection. And then party leaning and then friendship, and things like that. You'll find that. But most importantly, when we talk about reform, it is not just the judiciary that should be reformed. You see, INEC, if INEC had not been suffering from what I call partisan obscurantism, INEC wouldn't have, allowed for some of these issues that went this way to go that way. If you look at the two judges who had a dissenting view on this case, they lambasted INEC, that INEC ought to have been the umpire of this process.
There's a lack of independence that we're seeing from the INEC as a body.
They have an ailment. You cannot reform the judiciary only and then allow other institutions which are part of the electoral process. These institutions, you understand, must be reformed also. We must have an institution that is out there to discharge its obligation and objectives.
This is where it gets very concerning, though, because that's a very good point to make, because if we take the election tribunals or election petitions that we've seen so far, a couple of weeks ago, we had the Director of Voters Education of INEC join us on this program, and he stated that they have had hundreds of election petitions come through. I, as a citizen, can only wonder, yes, over 700. I, as a citizen, can only wonder, and I'm sure our viewers want to know, how much money parties, especially the main opposition party, end up spending on such election petition tribunals, because really and truly, that is of great concern to the people.
Well, you see, election tribunal is an harvest. Any truthful lawyer would tell you that once we get to election petition, whether you are leading cancer, whether you are the research team.
It is a time for lawyers to eat.
It is a time for...
It's your turn to eat.
That's the real money.
Because lawyers ought to be paid for their services and all that.
These election petitions is where the money is lying. So is it fair then to say that a lot of parties then get pushed into election petitions based on this? Is this why a lot of these cases come up, because it brews money?
A lot of issues go to election petition because of several reasons. One, the kind of electorate we have, or electors. Okay, because of the economic injustice in Nigeria. Okay, the average Nigerian have no source or solid means of sustenance. They can easily be recruited by the politicians. Talking about the politicians again, if you look at Section 130 of the Electoral Act, it talks about vote buying, talks about issues of gratification, collecting gratification for the purposes of change, and then it criminalized it, okay? But out there, you find the same politicians recruiting people for this purpose. Then you have people also who are willing to do same. And then you have INEC also that suffers from what I call partisan obscurantism.
And a justice system struggling to end this.
Yeah, so at the end of the day, all these problems you have here and there, you understand?
Obscurantism. Who have to get a dictionary.
Because
when we have guests, we just check obscurantism.
Yeah, so then you pack all these problems and then you throw it to the judiciary. Okay, and then the judiciary is battling with all the process, the dissipation, all the wrongs that have happened along the line. And the Electoral Act said that you must prove from polling booth to polling booth, from polling booth to polling booth. And you also have a situation where you have just 180 days, okay, to decide the matter. And then you have just 21 days after election to initiate the action. Okay, you find out that time is short, there's pressure on the Court of Assistance, there's pressure on the Supreme Court, there's pressure on the Court of Appeal. And then if this country, okay, if you look at civilized society where the government, as much as possible, take care of people's needs. If you look at Abraham Maslow's theory of need, it talks about the hierarchies of need. You take care of the basics for the people. Okay, when you're able to do that, you provide housing, provide mortgage system, provide all the basics. If you're able to do that, then the people will have a sense of belonging. Then they will be able to react positively to the politicians who will come to recruit them into all these things. And then INEC will have a mind of its own. Well, INEC have no mind of its own as we speak.
Evans Ufeli, before we go, what's your assessment of the fallout, of the Supreme Court judgment in terms of how the governor of Osun State has received it and how Senator Ademola Adeleke has received it. He just congratulated the winner and said it's not a do-or-die affair. And on the Oyetola side, there have been jubilation, a lot of jubilation. There's been a lot of jubilation on the streets of Osun. Of course, the PDP at the national level has condemned the outcome. What's your assessment of the response?
For the governors, the contestant, I think there's a lot of maturity that went into it, particularly coming from Adeleke, who made profound statements. Okay, who was able to accept the result, because at this stage you can't do anything about it. Supreme Court is the highest court in the land, and the kind of maturity I saw that emanated from his utterances is commendable. It's commendable. I must say that. Okay, and then from the APC side, they've been calm, even though their analysis have been on the issue of jurisdiction. That the Supreme Court has now affirmed a 60-year-old jurisdiction, that if you don't have jurisdiction is the lifeblood of litigation. We all know all that, but it doesn't mean the sins of the court should become the burden of the litigant. So I keep saying that. I remain on that issue.
Well, thank you very much, Evans Ufeli. Leila,
yes.
I think we've enjoyed.
I think we have. I think we've managed to cover everything here. Of course, electoral reform is something we also touched on. So very quickly, in 30 seconds, the Electoral Reform Amendment Bill. What are your thoughts on this? Well,
the bill have been to the president four times, and the 4 times he has turned it down, except for the last one where he said that if they will allow it to start to run after.
Thank you.
Those ones are the issues that
we'll have to go now. Thank you very much indeed. We've enjoyed this conversation.